Call the next case, 115985 State versus Larkin.
Your Honor, may it please the court, Matthew R. Williams on behalf of Haley Ann Larkin. May I reserve 3 minutes?
Very good. 3 minutes is granted.
Thank you, Your Honor. May I start, Your Honor?
Yes.
Your Honor, a brief rundown of this case is that Ms. Larkin was arrested for a DUI, third DUI felony in Jackson County in July of 2015. Normal proceedings were done. A preliminary hearing was held in October of 2015. In January of 2016, a motion was filed citing, among other things, that KSA 8-1025 was unconstitutional. The following month, in February 2016, this court determined that KSA 8-1025 was in fact unconstitutional. That was decided on February 26, 2016. And in this case, the motion hearing was argued on March 4, 2016, approximately 6 days later. At that time, the court denied the motion to suppress, raising sua sponte the issue that he believed good faith applied. We went to trial on the case. She was convicted. We appealed. The court found that while there was clear error in the sua sponte ruling by the court, no remedy was presented nor anything else. It was just found to be error. And so we filed a petition, find ourselves here today. Your Honor, with the reason I went through the dates and the reason that the preliminary hearing is important is that in October 2015, the Jackson County District Judge Michael Ireland passed away. And so when the preliminary hearing in this matter was actually underway, it was a temporary judge, Judge Burr, presiding over that. There was an assistant county attorney on that matter as well. Under the motion to suppress hearing that was held in February, or March 4th, a new judge, the District Court Judge Norbert Merrick, was now sitting on the bench, and the county attorney was covering the matter, rather than the assistant county attorney who had previously presented it. So at that time, the only people who were present at the preliminary hearing were defense counsel. Within the defendant's motion to suppress, the videotape was referenced several times, as well as the preliminary hearing transcript. At the time that the court, when the court called that motion to suppress hearing on March 4th, he called the case before either the defendant or the state's trooper who was on his way had arrived. The court said he wanted to get it in between two different hearings, to squeeze it in. He also stated that this was his fun for the day. At that time, counsel asked that he wait until the defendant was present. He said, if she shows up, she shows up. The state said, my officer's on the way. He said, well, we might be able to get him to testify later. He then said, I believe that the preliminary hearing transcript is good enough. I don't trust the video. I don't believe that's credible evidence. But I read the preliminary hearing transcript, so I know what I'm doing on this.
Does this portion of your argument fall under the category of judicial error or misconduct?
Yes, it does, Your Honor, because it is...
As a preliminary matter, was that issue preserved in your petition for review?
Only under the general judicial conduct, Your Honor. The statement of his having my fun for the day was specifically preserved.
So that was argued. As I look at the petition for review, it appears at least possible that that you don't argue that issue. You argue that the Court of Appeals erred when it upheld the good faith finding, but nothing else. Or am I wrong about that?
Well, Your Honor, initially we had brought the petition for 4 arguments and brought that back down to 2 due to limited resources.
Does that mean you didn't argue that in the petition?
It's part of the judicial error, Your Honor.
What's judicial error about this is my fun for the day?
It goes into-
What's wrong with saying that to the extent that you're wanting some sort of structural error by making that comment?
Your Honor, in a small scope, nothing. However, in the larger scope and what occurred throughout the course of this trial shows that this was from the start, from the very first docket that the judge was on, a pattern of his conduct that was just disregarding defense, if anything else. Your Honor, may I get some water, please?
Sure. Well, the context could be taken as, I've got a whole lot of things to do today. This is the one thing I'm looking forward to, and expressing it in that way. What's wrong with saying that?
Again, Your Honor, in that individual context, that would be nothing wrong. That would not be error. However, what that establishes would be that from the start, this is how he regarded it. He went on to...
He regarded it as what? I mean, minimizing its significance or what?
Generally just disregarding the defense argument, Your Honor. He had brought... At that time, the state had not, in its written brief or at oral arguments, ever brought forth the argument of good faith. It was never brought up. No evidence was presented on that, Your Honor. And the state based its entire argument off its brief, which was regarding the totality of the circumstances. The court found that the state hadn't the time to read the case or read the briefs or file a supplemental, despite the fact that both the court and defense counsel had done so. The state in this case said, I didn't read the brief. I didn't read those cases. I skimmed over it and yeah, that's it. She relied entirely off the totality of the circumstances stated in her brief. At no point was good faith argued at that. In fact, it wasn't even brought up until after she had closed her arguments, I had settled my arguments, and the judge was making his ruling. He, out of the blue, said, I believe that good faith applies here. So, as the law had applied at that moment, there was no question that the warrantless blood draw that was in question was unconstitutional, that it should not be allowed in unless the state were to bring in evidence at that time to provide it under one of the exceptions. They did not do that. They merely argued whether or not it was unconstitutional or not. The established law at that point said it was. If they had argued at that time good faith, that would have been appropriate, because then it would be bringing in the exception. That was not done.
I have a question, counsel. So this, again, is part of your judicial error argument. This portion, that he sua sponte ruled that good faith applied without waiting for the state to bear its burden.
Your Honor, one bleeds into the other. The sua sponte raising of the non-jurisdictional issue that was the state's burden to prove on the motion to suppress, state's burden to prove that. They had not done that. They had not presented any evidence. The court had not allowed it. And raising that argument on behalf of the state
Are you saying it demonstrates bias? Is that essentially what you're arguing?
Yes, Your Honor. In an adversarial system, when the neutral arbiter takes a step to proactively make the argument or progress the side of one side over the other, then he steps away from the neutral position and becomes one of the adversaries. And in this case, he raised good faith, said, I believe this is where the law is going, and because the state didn't have time, I'm going to raise this for them.
And this happened in a pretrial hearing.
In a motion to suppress hearing, yes, Your Honor,
How
and on the
long
motion
bef-
to reconsider.
Excuse me, how long before the trial was that hearing?
Approximately 2 weeks, Your Honor.
Okay. Was there ever any effort to remove the judge from the proceeding?
Not at that time, Your Honor.
Okay, at any point?
No, Your Honor.
Okay, thank you.
At that motion to suppress hearing, the judge had actually said, I'm going to, despite the complex arguments, we're going to rule on this today because it is only 2 weeks out from trial. He had, when making his decision, when the fact that this is sua sponte and it's improper was raised by the defense and the court's ruling was objected to, the court brought out several pinpoint sites regarding good faith and why he believed that was the appropriate response. Under ordinary circumstances, this wouldn't be unusual. However, because the state had completely ignored that argument, completely ignored the case law as it had been confirmed on the exact issue we were before the court on at that time, it seems that it indicates that he had intended to do this all along should the state not bring it up. On his order regarding the defendant's motion to reconsider, he said, I cannot be blind to this. I believe that this is where the law is going, and per Chief Justice Malone's dicta towards the end of State v. Rice, which is one of the cases cited, that I think that this is where this is going to go. However, that dicta was indicated to have done in error as well. It should not have been in there. It was improper. Because that argument in that case was never raised. So the judge in this case, Judge Merrick, was raising this argument that was improper to start with.
What about the Court of Appeals, as I read the opinion, conclusion that, hey, the state could have raised this for the first time on appeal anyway, so even if there was a mistake, that cures it?
Well, Your Honor, if it was a question as to whether or not it was a valid search, that would be the truth. However, in this case, the law had already established that this was a warrantless blood draw, that this was unconstitutional.
No, I'm just saying the Court of Appeals said that the state of the law is that the state can raise the good faith exception for the first time on appeal.
Well, Your Honor, had they raised it at that time, that would have been the only way to bring that in. However, they did not. In fact, that was never briefed by the state.
I understand your argument is they didn't raise it at the district court, but they did raise it. They argued it at the Court of Appeals.
But, Your Honor, it feeds into the judicial error in that. May I continue, Your Honor? Within that, the judge's error was raising the good faith argument sua sponte. So good faith directly tied into his error. The state arguing that they could raise it on this issue for the first time on appeal was improper because it allows a continuation of the judge's error, that the Court of Appeals established this is clearly incorrect, but does not provide remedy, and then in fact continues what the judge's error was and said we think this is okay. So what you're doing by that is it would essentially be condoning the judge's error in this. And I believe that's improper.
Any other questions? Counsel, you have your rebuttal time.
Thank you, Your Honor.
May it please the Court, the State appears by Assistant Solicitor General Natalie Chalmers. I would first like to note that it is the State's position that the only issues before this Court are whether the district, well, basically one issue that bleeds kind of sort of into two is whether the district court erred in sua sponte raising good faith. And then the judicial misconduct claim that is the same version of that exact issue. Anything else was not briefed or argued in the petition for review and should not be considered by this court. So anything about the comment, which I believe the Court of Appeals correctly found was an error about it being fun for the court to address this legal issue, is not properly before this court. It's the state's position.
Let me ask you about that. I'm wondering if there aren't, if I want to make sure we're not talking about two different things. It seemed to me that in the petition for review, counsel or the defendant identified errors that the Court of Appeals made. That's kind of in the first paragraph there, and they're not enumerated, but you could just write a number in there and state all four. Now then, the petition for review only argues one or two of those.
Correct.
And then at the conclusion, they say Court of Appeals erred on 3 of the 4 that were on the front. I mean, there's a little disconnect there. But I wonder if this isn't more of an issue of a failure to fully brief the error of the Court of Appeals as opposed to identifying the issue. And I'm trying to separate this out from the Castleberry decision where we were split a little bit. Now that was a med mal case and civil, but by the same token, it does seem like the defendant itemized the things they thought were error. They just didn't argue in the petition for review about it. Do you see a difference between those positions?
It is the state's position that it's because it wasn't argued that it was waived, that you have to show why review is warranted, and you can't do that if you don't argue why the Court of Appeals is wrong.
And so, in order to tag them for those mistakes, we would also need to look to see whether there was a supplemental brief. Because, the petition for review process allows
Sure.
supplemental briefing, and it seems like that's got to serve a purpose. I'm just trying to figure out how to identify the procedural misstep.
Well, I think the procedural misstep had the defendant listed the 4 issues and then proceeded to at least give something in the argument section. Also, this petition for review is over the page limit, just fun. Is some argument as to why that issue was an error by the Court of Appeals. The conclusion of the error, of course, I wouldn't be complaining. It can be pretty summary. Whatever this court rules wants it to be.
In addition to an argument, is it required that the petitioner simply state that a ruling was error by the Court of Appeals?
I think you have to state that it was error and explain why review is warranted of that error.
I can't find in the petition for review where, for example, the petitioner does describe the Court of Appeals ruling as, for example, affirming the sentence imposed, but I can't find anywhere where it says that that was error. Does that make a difference?
I do think that they should have to tell you what it is they want them to review, what they want you to review, and why the Court of Appeals actually made an error. If all I have to do in my cross petitions and conditional cross petitions is just list issues and not explain why you should take them up, my job becomes easier, but I didn't think that was the rule. So I don't, there might be a variety of violations of this rule, but the big one that I noticed was that why review is warranted isn't done. I don't think it's adequately briefed, anything besides the sua sponte good faith. As to the sua sponte good faith issue, this court recently decided in Perkins that this is indeed a case that good faith, well, not this case, but the reading of the DC-70, which is mandated by 8108K, or was mandated by 8108K, is a reason to have the good faith exception apply. The good faith exception should apply because the officer was following the law. I know that the appellant keeps discussing that the state didn't present sufficient facts, and I'm just unclear what other facts they wanted. The Court of Appeals talks about how at the preliminary hearing, the state put on the evidence that the officer did indeed read the DC-70. The defense counsel himself stipulated that the officer read the DC-70. As a matter of law, the officer was required to read the DC-70. This is an objective standard, so I don't think there are any facts that the state failed to present. I would understand it being more of an error if this judge put on facts for the state, but I don't believe that happened here. As to whether or not it was error, I know the case law says that you're not supposed to raise something sua sponte unless it's jurisdictional. And I don't think that case law applies I'm not sure it applies in the criminal context, but it certainly doesn't apply in that black and white terms. Defendants do have things that they can raise for the first time, or the court can raise for the first time. They can try and stop prosecutors from committing error. They can stop, they're required to give lesser included offense instructions by statute. This court has upheld a district court sua sponte raising self-defense immunity for the first time. So it's not that black and white. But even if there was error here, the state's point and the Court of Appeals point isn't that there was an error, but that any error was harmless. Because the state could have, for the first time on appeal, actually the Court of Appeals in Perkins helped the state raise the issue by asking both sides to brief it. And then this court said that was the proper way to do it. But in Daniels, this court said, you can raise good faith. The state can raise good faith for the first time on appeal. So if the state can raise first time on appeal, there's no harmful error here. The right result was reached. The exclusionary rule shouldn't have applied. Perkins says that. I don't see any reason to reverse Ms. Larkin's conviction. If there are not any further questions, I would ask that the conviction be affirmed.
Thank you.
Thank you.
Counsel, rebuttal?
Thank you, Your Honor. To address the briefing issue, it was simply a matter of time. With the strength of the arguments, I believe the sua sponte is the most erroneous.
Can you point us to anywhere in your petition for review that I'm not seeing where you say the Court of Appeals erred in any respect other than its ruling on the sua sponte issue?
On that, Your Honor, they simply said this was clearly an error and stopped. There is no remedy presented.
I'm asking about your petition for review.
Yes, Your Honor, it mentions that there was no remedy presented on this, that they just established that it was error with nothing else further.
I understand, but on the issues that you, so let's just take, for example, the sentencing issue. Can you point us in the petition for review to where you say the Court of Appeals erred in resolving the sentencing question?
No, Your Honor, that was one of the issues we did not brief.
And the same would be true of the other issues that you didn't brief, correct?
Your Honor, the issues that were briefed were the sua sponte raising it and the judicial conduct throughout there.
Okay.
Your Honor, the state mentions that there is not really a criminal context for raising a non-jurisdictional sua sponte. There was a ruling, unpublished Court of Appeals case decided on October 27, 2017. That was a State versus White, that the state argued it is improper for the courts to raise a non-jurisdictional issue sua sponte. And that was approximately a week and a half, 2 weeks before the Court of Appeals argument in this matter. So the Court of Appeals had decided in a criminal case that it was improper for the court to raise non-jurisdictional issues sua sponte. Within this, Your Honor, what we see is the judge stepped away from his neutral position when he established that I'm going to say what I believe the law should be, where I believe it's going, and raise this argument that was detrimental to the defense, to the defendant, on behalf of the state because I believe this is proper. Then he is stepping away from that neutral arbiter position and becoming part of one of the oppositional counsel. In this matter, it would be the state. And when he does that, it is impossible at that point for the judicial conduct to be proper, because at that point he's already abandoned it wholesale. With raising the issue sua sponte, Your Honor, brought it up, waited for the state, even said hint, hint before providing that ruling. Yet, if the state were to, may I continue? May I answer, Your Honor?
Yes. Please finish your response.
Thank you, Your Honor. Should the state be allowed to argue the very thing he made in error for the first time on appeal? This isn't the first time that good faith has been raised. It was raised at the trial by the judge. And that is an error, clear error. The only remedy for this would be dismissal of it.
Anything else?
Thank you, Your Honor.